Okay, I am reading Article 3, Maxims of Practice and Pleadings from the book called Suits in Chancery by Henry Gibsons. We are in the section here, Maxims applicable to the court and to its practice and pleadings. This article is made up of, I believe, 4 sections. So I'm going to start with section 61, maxims applicable to the court and its orders. The following are some of the maxims applicable to the court and its orders. 1. Actus curia neminem gravabit. Okay. An act of the court injures no one. Whenever the court makes some order or does some act on its own motion during the progress of a cause, such order or act will not be allowed to work an injury to any of the parties. Well, that happens all the damn time. I don't know what the hell they're talking about. Where a decree has been delayed by the act of the court, it will, if necessary to justice, be entered nunc pro tunc. 2. Actus judiciarios, I don't know what this says, but in English, a judicial act outside of the judge's authority is null and void. A judicial act outside of the judge's authority is null and void. Interesting, that's true. 3. Consent makes law. See, there you go. That's where they get us. They deem giving consent. We give consent for them to do all this shit that they do to us sometimes at the court, especially if we're unaware of how the court operates and what exactly they're doing and what's the nature and cause of the actual case, the actual event that they're putting us through. So whatever the parties agree to during the process of a suit is binding upon the court if the parties consenting are under no disability, and if the consent is in violation of no law. Every person, sui juris, can do what he pleases with his own, so long as he violates no law and injures no one else. The agreements of parties during the progress of a suit are favored, and the court cannot go behind them or revise them or disregard them or set them aside except for fraud, accident, or mistake. Where parties consent, they bind the court. Where they do not or cannot consent, the court binds them. Conventio vencit legem. There you go. So here it is, number 4. The practice of the court is the law of the court. Rules of procedures. The rules of procedure are indispensable to the orderly administration of justice, and all courts have such rules and require strict obedience to them. They are a part of the means whereby the law is enforced. Law would be of no value if there were no means of enforcing it. Another maxim is, when anything is commanded, every means of accomplishing it is also commanded. So, when courts were created, by necessary applications, power was given to them to make such rules of practice as are necessary to enable them to apply and administer the law. These rules, when established, have all the force and effect of law, as well upon the courts themselves as upon their officers and litigants, until duly changed on due notice. Number 5. What ought not to have been done is valid when done. Thus, a decree that is erroneous is, unless duly reserved by the Supreme Court, as binding on the parties as though in strict accordance with the law and the facts. So, an injunction that should not have been granted must be obeyed as implicitly as though fully warranted by the facts. All irregular procedures are valid unless the irregularities are duly questioned and corrected. In brief, every judicial act is binding so long as it is not appealed from or reversed by writ of error. However, irregular or full of errors the act may be. But a judgment or decree that is void binds no one, benefits no one, and protects no one. Void things are no things. Number 6. All things are presumed to be rightly and regularly done. The courts presume that whatever is done by a court or by an officer of the law is properly done. That's what they're presuming at all time. Everything is properly done. Whatever is done by a legislator is presumed to have been done correctly. The courts presume that when a court is of general jurisdiction pronounces a decree that every necessary step preliminary thereto was duly taken. All presumptions are in favor of the regularity of the proceedings of all sworn officials. There's a presumption that everybody's a freaking saint and they're doing everything right. It's always a presumption. As the officers are doing everything right, and whoever they're bringing in, there's a presumption that poor bastard did everything wrong. But the officers, it is presumed that they're doing everything right as per the court rules. Isn't that interesting? That's their presumption. Unless it is rebutted, questioned, duly questioned. Let's see, we're here. He who does anything by command of the judge will not be deemed to have acted from an improper motive, because it was necessary for him to obey. Excuse me. This rule protects a clerk who pays out money or does any other act by order of the clerk of the court. It protects the sheriff in the proper execution of the orders, decrees, and process of the court, and protects receivers, special commissioners, and others who do any act in pursuance of an order or decree of a court. The party dissatisfied with any such order or decree must take the proper steps to have it suspended, corrected, or reversed. 62. Maxims applicable to the practice of the court. The following are some of the principal maxims that may be applied to questions of practice. 1. What does not appear in the record and what does not exist in fact are one and the same in the law. You hear that? If it's not on the record, it does not exist. Courts can act upon nothing that does not duly appear in the record. Courts of law may hear and determine, but courts of chancery must see and determine. Interesting. They cannot take cognizance, meaning jurisdiction, of oral statements unless and until reduced to writing in due form and made part of the record. The chancellor cannot regard his personal knowledge of men, character of facts, for these are not in the record. This maxim is sometimes more tersely expressed thus: what does not appear in the record does not exist so far as the suit is concerned. All right. You see, that's why it's important to put it on the record. We just creating records when we go to court, and we bring it up to higher and higher administrative processes, eventually to a chancery or a chancellor, and then everything is corrected, because everything must be followed as per the principles of law. Okay, so number 2. In a judicial proceeding, nothing is believed unless proven upon oath. This is one reason why the chancellor, the clerk and master, the solicitor, and the sheriff are all sworn. No witness can be heard unless sworn, or unless his oath is expressly waived. Wow. How many people go to court and they don't make any sworn statements at all? You know what I mean? Very interesting, but it is accepted. Statements of facts made in court by parties or on behalf of parties will not be heeded unless sworn to or agreed to by the opposite side. It has to be agreed to. The court cannot credit anything not verified by the oath of the proponent, and this is the reason why affidavits are required in support of motions. I see. Interesting. Number 3. The situation of defendant is preferable to that of the complainant. Listen to this. This is interesting. The situation of the defendant is preferable to that of the complainant. The reason of this rule is that the burden of proof usually rests upon the complainant, and ordinarily the defendant need make no proof until the complainant has made out a prima facie case. The complainant must satisfy the court that he has a right to the thing in dispute, and until he does so, the defendant can keep his arms folded and his mouth closed. So, where each party is equally at fault, the court will not aid either. As a rule, for in pari delicto posterior est conditio defendentis. Both the defendant and the possessor may stand still until the complainant has proved a right, that he has a right to do so. That's interesting. So that when, let's say we're taking the court for something, and the prosecutor is basically just making all these damn claims. They violated the law and violated this and violated, well, the proof and burden lies with them, on them. What makes you believe, or what evidence do you have that I am an officer under those legislations? What evidence do you have that I am a trustee, a volunteer trustee under administrative law? What evidence do you have that I even hurt anybody? I mean, what's your claim? Who are you? Are you bringing in the name of the state? Oh, you're a witness. Oh, you're not the actual individual who's bringing in a claim. Who's bringing in a claim? Yeah, so this is interesting. This is interesting. So, number 4. We're here. Number 4. Right here. Every innovation disturbs more by its novelty than benefits by its utility. This is especially true in matters of pleadings and practice. Solicitors, from inexperience or carelessness, are constantly departing from the proper form of pleadings, orders, and decrees, and are constantly making innovations on the regular practice of the courts. We're right here. See? This maxim applies as well to questions of pleading and practice as to the property rights. See this one right here. Let's see. Here, stand by what has been decided and do not disturb what is settled. Yep. This was mentioned earlier. Okay. This maxim applies as well to questions of pleading and practice as to property rights. Number 5. He who does anything by another does it himself. The act of the agent is the act of the principal, and among partners, each one is the agent of all the others. If the principal or master ratifies, you see what it says? If the principal or master, meaning these are interchangeable, principal and master, ratifies an act of his agent or servant. Oh, okay, so principal, agent, master, servant, okay. The effect is the same as though such act was expressly authorized before it was done. For this thing right here, which is 8, every ratification of what has been done is the equivalent of a prior command to do it. Interesting. Here, okay. Delegated power, however, cannot be delegated. Representation in courts is indispensable, and litigants will be as fully bound by the acts of their solicitors as though such act has been done by themselves in person. When the court is once satisfied that a solicitor is authorized to appear, it will not question his authority to bind his client in any way or by any act or agreement in the progress of the cause. And that solicitors are sworn well and truly to demean themselves to the court will presume they have authority to appear when the opposite side or the client himself does not dispute that authority. Number 6, anyone can waive a law made for his benefit. Wait a minute. Anyone can waive a law made for his benefit. Interesting. So, give me a minute here. It says here, no one is obligated. No one is obligated to act or to make use of all the rights he is entitled to. He may waive any of them. You hear that? He may waive any of those rights. And the failure to exercise a right in due season will generally be deemed a waiver. You hear that? That's messed up. But it is what it is. That's what's happening. That's what we must be wary about. No one is obligated to act on or to make use of all the rights he is entitled to. He may waive them at any time. He may waive them. Well, not at any time, but he may waive them. And the failure to exercise a right in due season will generally be deemed a waiver. And if, in consequence of a seeming waiver, the opposite side has taken a legitimate step, the party making the waiver will be concluded and is stopped from recalling his waiver. Damn, he can't say, no, my bad, I want it back. You waived it, it's gone. This rule is strictly enforced in practice. Number 7, he who enjoys the benefit ought also to bear the burden. Sheesh. This rule is enforced by requiring the party who obtained a benefit in a judicial proceeding to pay a part or all of the costs when they cannot be otherwise made. You know what? I had an interesting case one time. I brought I brought a claim against the Attorney General of Belize, and I was my first time. I've never done that before, but I brought it in as the actual trust, and I said I'm ready to give a bond if this claim does not go through. And anyway, they struck out the case because my crucial error was to bring in the claim in the name of the trust. It should have been as a trustee, me as a trustee. I learned that. But then what happened is that no cost. They just struck it out, and the Attorney General's office is like, "No, we don't want no cost to him," and which is very interesting because just by giving or offering the bond, they're like, "Nah, we don't wanna, we don't wanna mess with that." So I found that very interesting, but that was a good experience. Let me see, where were we? Okay, this rule. Okay, I think we're at number 8. Yeah, here we go. Where the law requires anyone to show cause, the cause must be just and legal. In court, a party is frequently required to show cause. 1. Why he did so and so, or why he did not do so and so, or why he should be allowed to do so and so, or why the other party should not be allowed to do so and so. It may be stated generally that what is meant by showing cause is showing good cause, that is, showing a good, legal, substantial, and meritorious reason or reasons justifications or excuses for the action in question. The law despises trifles and quibbles. What? Quibbles, okay. And when the law or the court requires a party to show cause, such party must, in good faith, make such a showing as to demonstrate that justice is clearly on his side. If he is showing cause to be relieved or to shield himself, he must make it clearly appear that he has been guilty of no inexcusable laches or negligence, and of no acts of bad faith or disregard of duty, and that he has a meritorious claim or defense. In a word, he must show good cause. That's it. He must show good cause. If he is showing cause to obtain the right to do an affirmative act which should have been done or applied for in due season, he must likewise show good reason for excuse for his delay, and show that he acted as soon as he had knowledge and an opportunity. Good faith, diligence, and merits must be shown by every party who comes into the Chancery Court for relief. A party applying for leave to do something in court which should have been done before must show not only a good excuse for his failure to act in season, but must set forth such merits as will show that he has the right on his side. And these merits must be shown not by general allegation, but by specific facts. A party required to show cause is ordinarily a suppliant for the mercy of the court, and he should realize his extremity and conform to every requirement of the law, the practice, and good reason. And this cause, or good cause, should be shown, 1. In due season, which means at the first opportunity after its necessity became known. 2. In due form, that is, the manner required by the practice of the court. And 3. By due particularity, that is, by a full disclosure of all the facts and circumstances bearing on the matter in question. And the writing set forth this good cause thus shown should be verified by the oath of the party or of his solicitor when the facts are in the latter's personal knowledge, but not otherwise. The most usual cause, or the most usual cases where a party is required to show good cause are: 1. For not answering in season; 2. For leave to withdraw an answer and demur or plead; 3. For not amending his bill in season, or not sooner applying so to do; 4. For setting aside a pro confesso; 5. For amendment to answer; 6. For leave to re-examine a witness; 7. For a continuance; 8. For recommitment of a master's report; 9. For setting aside a sale; 10. For leave to file an amendment or supplemental or cross bill; 11. For extension of time to take proof; and 12. For doing or having done any act in court out of course, or for undoing any act in court that has done in course. So, we are in section 63, 24 minutes in. Let's see how much more we got right here. Oh, I think we could do this. This is not a problem. Let's just finish it off. Section 63 right here. We could do this. Okay. Maxims applicable to pleadings. The following maxims apply to pleadings and their interpretations. 1. He who makes assertions that are contrary to each other will not be heard. Interesting. This maxim applies both to pleadings and proof. A bill or answer containing contradictory statements becomes a nullity as to such statements. Nor will the court allow a pleading to be amended when the amendment is contradictory or repugnant to the pleading, So, testimony that is contradictory destroys itself, and a witness who contradicts himself is not to be heard. 2. That ought not to be alleged, which, if proven, would not be relevant. Okay, that ought not to be alleged, which, if proven, would not be relevant. Okay, so no useless allegations should be made, and no surplusage inserted in pleadings. Poetry, rhetoric, sarcasm, pathos, all are alike irrelevant and impertinent, and will be stricken out on motion. I think that's what they did on me. Hey, that was good. Yeah, it's good. Number 3. Written instruments should be liberally construed so that they may stand rather than fall. This is our rule in dealing with bills. The court making every reasonable presumption in their favor when assailed by a demurrer or a motion to dismiss. The English rule is the reverse, following the maxim, this right here, 18, which is right here. An ambiguous pleading ought to be interpreted against the party pleading it. This maxim is properly applied in England, where all solicitors are thoroughly trained and skilled, but in Tennessee, where solicitors are admitted to practice without a thorough preparation, a liberal interpretation of pleadings and other legal instruments is necessary and equitable. We're back right here. Right here. In Tennessee, a liberal interpretation is given to all writings. The purpose of the court being to ascertain and to give effect to the intention of the makers of the instrument. The intention is the substance. The words are but the shadow. Wow, words are the shadow, and the intention is what they're looking at, the substance. And so, the intention is the only infallible touchstone for the interpretation of contracts. In construing wills, the intention of the testator is the polar star by which the court should be guided. The intention of the writer is the soul of the writer, or as it has otherwise been expressed. Words are the body. The meaning is the soul. That makes a lot of sense. The office of interpretation is to deduce the true sense of the words and not to inject a false sense into them. This right here, let's read it, 21. Let's see. Right here. That interpretation which is born of the bowels of the case is in law the fittest and most powerful. Okay, that's right here. Okay, let's start right here now. And while the words are deemed of less importance than the meaning of the entire instrument, nevertheless, it is only by means of the word that this meaning can be ascertained. This one right here, 22 right here. It is a guess, not an interpretation, which disregards the words of an instrument. Okay. Neither bad writing, bad punctuation, nor bad grammar will, in the least, prejudice the instrument, for mala grammatica non vashat chartman. Okay. That's 23. Okay, I'll look that up somewhere else. Okay, number 4. A false description does no harm, This is a maxim of frequent application and applies to cases where the wrong name is given to a person or thing otherwise sufficiently described in the instrument. Where a bill is misnamed, the court will disregard the name if it contain an equitable ground of suit. There you go. Makes sense. So, okay, here we are. The useful is not vitiated by the useless. Surplusage works no injury and may be ignored. This rule applies to unnecessary words and phrases in deeds, contracts, and pleadings. They are deemed mere trifles which the law disregards. The court will order surplus matters in pleadings to be stricken out or will ignore them. Other principles and maxims. For the convenience of chancellors and solicitors, the following additional maxims and principles are here inserted. No man is bound to criminate himself except before his God. Meaning, no man can be forced to criminate himself in any court except the court of his own conscience. Damn. It's deep. That's deep. Number 2, the act of God or of the law. You see how it's synonymous. Law, God, the act of God, act of law, synonymous. Causes a loss to no one. As in cases of accidents and forfeitures caused by flood, pestilence, and sickness, or an act of legislator put in force from and after its passage operating on contracts by parties before the law was made known. Number 3, a judicial act outside of the judge's authority is null and void. As a decree or order not warranted by the pleadings, or a decree in a case over which a court has no jurisdiction. 4, suits involving dower, life, liberty, and revenue are favored in the law. 5, that is deemed certain which can be made certain, as when one instrument calls for a second and the latter contains that what was deficient in the former. Okay, makes sense. 6, when the reason for the law has deceased, the law itself ceases. Wait a minute. When the reason for the law has ceased, okay, the law itself ceases. Okay, that makes sense. Now, as the laws in the Code of 1858 never repealed relating to slaves and free Negroes. What? As the laws in the Code of 1858 never repealed relating to the slaves and free. Really? What was he trying to say? They never repealed that? Okay. 7, neither a debt nor a contract are local in their nature. So they're foreign, that's what it's saying. Okay. Suits to recover debts and suits based on contracts are called transitory actions and may be brought wherever the debtor is found. 8, the good faith and office of a judge cannot be called in question, but his knowledge of the law or facts of the cause may be. That's true. That's true. We're not going to take the office. We're not going to take the judge to court if we want to make a claim. We're not going to make a claim against the judge. We're going to make a claim against the man in personam, who is going outside the jurisdiction, outside of what an honorable judge should be doing. That we go in personam, because the judge is a thing. Anyway, this makes a lot of sense though. Number 9, the laws pays no attention to trifles. Very small errors are always ignored. They don't give a damn about those little errors. It's your intent, right? It's our intention that is the substance, not those Striffles. 10. The Lord's day is not the court's day. Okay. 11. No suit can be brought upon a contract without a supporting consideration. It's true. That's true. Makes a lot of sense. In order for a contract to be valid, I mean, there has to be equal considerations on both sides, right? But if only one side is offering it and the other side is not supporting any, it doesn't have any supportive consideration, then it's not a contract. There's no suit. Number 12, no suit can be brought to enforce a fraud. A complainant must have clean hands. That makes sense. Number 13, no suit can be brought to enforce a contract in violation of a law. You can't be like, hey man, we had a contract. He was supposed to go beat this guy up and he didn't do it, so I want the court to, enforce this contract. Like, wait a minute. You mean beat this? That's against this violation of the law. No. In fact, no, hell no. So that makes a lot of sense. 14, the law arises out of the transaction. Listen to that. The law arises out of the transaction, right? Because the law is the shadow of which the facts cast. So the transaction itself already creates implied contracts, implied agreements. So laws are already attached to those implied contracts, agreements. Therefore, the law arises out of the transaction. Makes a lot of sense. 15. The express mention of one person or thing in a written instrument is equivalent to the express exclusion of all other persons or things. Thus, a deed to A is a deed to him alone and to no other person. And a devicee to B, is that how you say that? A devicee? Let me see this. I forget how do you pronounce this? A device? No. Leave. Yeah, there you go. Leave. Okay, so let's see.
Devise.
Yes, just device. Okay, I'm just overthinking it. The deed to A is a deed to him alone and to no other person, and a device to B. What's going on here? Okay, having technical issues, and it crashed. Let's see. We'll get it back. Let's see. There you go, and we're back in action. So here we go. We are in this one right here. Thus, a deed to A is a deed to him alone and to no other person. And a device to B is, in effect, excludes all others. 16. It is useless to prove anything which, when proven, would be immaterial. Yeah, definitely makes a lot of sense. Okay. 17. The heir and his ancestors are one and the same person. Oh, okay, that's interesting. The heir and his ancestors are one and the same person. That is, one in right. The heir succeeding to the right of his ancestor, just as the king never dies. That's interesting. That's a good maxim right there. 18. Ignorance of the facts excuses, but ignorance of the law does not excuse. Oh, okay. Ignorance of the law does not excuse in criminal. It does not excuse in criminal cases, but may excuse in civil cases. Oh, because civil has to do with facts. Criminal is like, okay, you just committed a crime. You can't say you didn't know you can kill that individual. However, how about when they say, oh, it's a crime to drive without license? See? But because you see that they're bringing that in a civil. They're just calling it criminal. It's colorable. But anyway, number 19. In similar cases, the remedy should be similar. Okay, makes sense. 20. Where the rights of the parties are equal, the claim of the party in possession is preferred. If neither party has any title to the property, real or personal, in dispute, the court will refuse to disturb the possession of the defendant. Possession is a sufficient defense against everyone except him who has the legal right to the possession. Possession is a sort of what is this word? What is this word? What is this word? Let's see. What is this word? Just begun and not. Let's see. Not.
Inchoate.
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 Inchoate. Inchoate. Inchoate means just begun and so not fully formed or developed. Rudimentary. Why didn't you say rudimentary? Possession in sort of an inchoate title and may ripen into a perfect title if continued. 21. In law, the proximate and not the remote cause is to be considered. The proximate and not the remote cause is to be considered. Number 22. It is the duty of a judge to decide according to the allegations of the pleadings and to the pertinent proof. A decree that is not supported by the pleadings is void. A decree not supported by the evidence is voidable on appeal or writ of error. 23. The law does not require anyone to do what cannot be done. That's right. That's right. The situation of the person in possession is better than that of the claimant, where neither has any title to the property. Yeah, because if the claimant he ain't got no title, and the defendant don't got no title, but the defendant is in possession of it, well, the situation of the person in possession is better than the one who's making the claim. Because how the guy who's making the claim or the one making the claim has no rights, has no legal title, has no possession. So yeah, it makes a lot of sense. Number 25. The necessity is a defense to what necessity compels one to do, as when houses are blown up to stay. As when houses are blown up to stay a conflagration. To stay a conflagration. I don't even know what conflagration is, but we can look up. Conflagration. Okay, an extensive fire which destroys a great deal of land property.
Conflagration.
Conflagration. Okay, there's a new word we learn every day. So it says here, as when houses are blown up to stay a conflagration. What? The necessity is a defense to what a necessity compels one to do, as when houses are blown up to stay. Oh, like let's say there's a house that is on fire, and then you want to go blow it up, but it's already burning. Why are you gonna blow it up? You know, it's like, why? I think that's what it means. But anyway, 26. No one, and I mean no one, can be forced to sell his own property even for a fair price. Can't be forced. Can't be forced. But it may be taken for a public purpose on just compensation being paid therefore. 27. It is known by its associates. Writings may be deciphered by using known letters or words in the same writing as guides. So, the meaning of doubtful words may be made plain by the context. The best interpretation is obtained by considering what goes before and what follows. 28. What is improbable or dishonest is never to be presumed. On the contrary, the law presumes in favor of truth, honesty, and probability. 29. The greater always includes the less. An authority to do a greater thing will authorize the doing of a less thing. 30. Maxims have an inherent probative force and need not be proven. That's right. The reason of the law is the soul of the law. The reason of the law being known, its interpretation is unknown. No, sorry, is known. Its interpretation is known. Okay, 32. No one ought to suffer because of what others have said or done. 33. The value of anything is estimated according to its worth in money. 34. When property perishes, the loss falls upon its owner. When property dies, is burned or otherwise destroyed or impaired. What is this? Something like litigation. What is that word? Curing litigation? I don't know. Litigation without anyone being to blame. Therefore, the owner of the property must bear the loss. You're right. The welfare of the people. I'm right here, see? The welfare of the people is the supreme law. The rights of the individual must be subordinate to the public good. You see, your rights as an individual is subordinate. It's beneath, secondary to that of the public good. The welfare of the public. See? It says it right there. 36. When the foundation is removed, the superstructure falls. 37. When the principle is removed, its adjuncts are also removed. The accessory follows the principle, and what is incident to a thing goes with it. Okay. The accessory follows the principle, and what is incident to a thing goes with it. 38. What is superfluous works no injury. Surplusage does not vitiate. 39. The suppression of a truth is equivalent to the suggestion of falsehood. Okay. Makes sense. Property is worth only what it can be sold for. Yes. Yes, you could say this is worth $1 billion, but if nobody's paying you for that, it's not worth that. But if you say this banana is worth $38 million with a duct tape on it, and then somebody buys it, yeah, it was worth that. It was worth that. Property is worth only what it can be sold for, right? Number 41. Where the reason is the same, the law is the same, and where the facts are alike, the decree of the court will be the same. 42. He who that's I think that's referencing, like for example, like when you bring in case law, you know, to substantiate your I don't know, I mean your substantiate your either your claims, your defense, I guess. But anyway, number 42. He who consents to what is done cannot complain of it. No right of action accrues to a person who agrees to what was done, even if it injured him. 43. Words referred to are considered as inserted. When a deed, pleading, or any written instrument refers to another writing, the latter is deemed incorporated in the former. And that's it, guys. We're going to call it a day. So again, this is... No, man. Hold on. Again, this is a treatise in suits and chancery, setting forth the principles, pleadings, practices, and proofs of and processes of the jurisprudence of equity, and giving numerous illustrative forms, pleading, writs, orders, reports, decrees, and other proceedings in suits and chancery from their beginning to their end. Henry Gibson. Peace and love.